Florida probate litigation, and the right to see what's on your cell phone. Hello, my name is John P.L.L.C. I'm a probate litigator in Florida with the P.L.C. law firm. Our law firm in West Palm Beach handles estate litigation, probate litigation, lawsuits and trials involving wills, trusts, estates, and guardianships. We also handle related appellate work and business litigation and commercial litigation. I'm going to be speaking to you right now about 9 things you need to know about e-discovery in Florida. Specifically, I'm going to give you 9 topics and 4 cases that you'll want to read if you're in the middle of estate litigation and somebody is trying to conduct discovery or learn what's on your iPad, your cell phone, your hard drive, your laptop, or your computer. We're going to discuss these issues very, very quickly, and I'm going to give you the 4 cases that your Florida probate litigator should read and should be familiar with. If there's discovery in your estate litigation, if there's a motion to compel discovery, or there's a motion to inspect your handheld device, iPad, cell phone, hard drive, or computer. Here are the 9 things that you need to know about e-discovery in Florida estate and trust litigation and lawsuits. 1, before somebody can look at your cell phone or your hard drive or your computer, consider whether there was any destruction of any evidence that would compel a court to let someone go into your private computer or cell phone. Secondly, consider, rather than having someone inspect a computer or your cell phone, is there another method of discovery that will be less invasive? 3, is there another way to provide documents which may be requested without somebody actually looking at your cell phone or inspecting your computer hard drive? For example, can you simply produce documents or find them and print them yourself and produce hard copies? 4, is there a less intrusive manner to conduct the discovery rather than hiring some expert who's going to examine or look at your iPhone or iPad, computer, or hard drive? 5th, you should balance the rights of one's privacy. In Florida, everybody has a right to privacy. It's in the Florida Constitution. And in will contests and trust lawsuits in Florida, many times people are trying to get documents and information through discovery and subpoenas. A right to privacy is very important and it's very valuable. In fact, Florida appeals courts in probate cases and other cases have upheld one's right to not only privacy, but the non-disclosure of documents and your rights to financial privacy. Not everybody can necessarily learn how much you're worth, where your assets are, or what's going on with your finances. So consider, for the 6th point, whether any communications are privileged. If someone wants to look at your cell phone, do you have any communications with your spouse, your lawyer, your accountant, or your clergy that might be otherwise privileged? 7, if you're in the middle of e-discovery and there's a request to look at your iPhone, your cell phone, your handheld, your Samsung, your laptop, computer, or hard drive, consider whether the request that's being made is overly broad. Generally speaking, you'll hear probate lawyers in Florida talk about discovery is casting a wide net. And while that's certainly true, it can't be overly broad, it can't be unduly burdensome or excessively costly. The 8th point on e-discovery in Florida is who's going to conduct that inspection if an inspection of your cell phone or your computer is ordered. Is it going to be some other expert or is it going to be your expert? And you might want to consider having your own expert do it or asking the probate court judge to permit your expert to do it. Why? Because you don't want some third party that you didn't hire looking at your private documents, private computer, and confidential communications. Last point, 9th point on e-discovery in Florida is who's going to pay for that inspection? Should it be the person who owns the cell phone or the iPhone or the computer, or should it be the person requesting the information? Or should you split it half-half? And who pays for your attorneys who should be able to be there, be present, and oversee the process of inspection? Those are the 9 points on discovery of information on your cell phone, iPhone, iPad, computer, or hard drive when you're in the middle of Florida probate litigation. I'm going to give you these 4 cases now that your Florida probate attorney or your Florida probate litigation law firm should know and read. Starting in 1996, the Strasser case, S-T-R-A-S-S-E-R, 669 Southern 2nd, 1142, a March 20th, 1996 case from Florida's 4th District Court of Appeal. Next, in 2005, came the Menke case, M-E-N-K-E. M as in Mary, E as in Edgar, N as in Nancy, K as in Kilo, E as in Edgar. 916 Southern 2nd 8, September 28, 2005 case. Next, in 2010, came the Holland v. Barfield case, Holland, 35 Southern 3rd, 953, a May 7, 2010 case from Florida's 4th District Court of Appeal. In 2014, a cell phone case. Can somebody in the middle of a probate lawsuit look at your cell phone, read your cell phone, read your texts, read your emails, read your Snapchat? This is a 1st District Court of Appeal case. The citation is 148 Southern 3rd, 163, an October 13, 2014 appeal case involving e-discovery or discovery of one's cell phone, the inspection of one's cell phone in Florida litigation. My name is John P.L.L.C. I'm with the probate litigation law firm, the P.L.C law firm in West Palm Beach, and this concludes my remarks on discovering information on your cell phone or your computer in Florida litigation.